Erik Brenner with Hilltop Wealth and Tax Solutions. Glad you are with me today. Today, we're going to talk about a very important topic, estate planning. You know, we see a lot of people that do not have an updated estate plan or do not have an estate plan at all. So I wanted to go through with you really some important things to consider as you're thinking about an estate plan. So what we're going to do is we're going to dive right in and give you a lot of great information. So let's talk first about, for those that are new to Hilltop and are not familiar with us, we are a fiduciary advisory firm. We have offices located in Fort Myers, Florida. We have 3 in Northern Indiana, which our main office is based in Mishawaka, Indiana, and Royal Oak, Michigan, as well as we work with a lot of clients remotely around the country. We are a registered investment advisor. So that means we always must act in the best interest of the client. We are fully independent and a fiduciary, as I mentioned, and we custodian through large custodians like Charles Schwab. We have an extensive experience in helping people navigate their financial life, especially before retirement and during retirement. And everything that we do is transparent, and we want people to know that and how we work. So let's talk about estate planning. You know, estate planning can be something that's a broad term, and a lot of times people don't realize everything that goes into it. So you really do have documentation, a will, a durable power of attorney, a trust. Okay, those are documents that you would get done, legally done, to make sure that when you pass away, you know, these documents state where does your estate go. But a durable power of attorney or a power of attorney for healthcare documents in general, that's while you're living. You know, what do you want to see done while you were living? Who's going to take care of your financial situation? Who's going to take care of your health decisions? All of that. So we're going to talk more about it, but think about an estate plan as a comprehensive in nature. Then you need to think about, you know, when you do pass away, what are the funeral arrangements? Do you want a prearranged funeral? You have life insurance policies you have to think about. You have beneficiary designations you have to think about. So there's a lot of things that go into play when it comes to the estate plan. So really you have 2 choices when it comes to estate planning. I say you can leave all or most of it to the ones you care about, or leave a large portion to the IRS and probate costs. Obviously, most people do not choose option number 2. They want to leave it to those that they care about or the charities they care about. They don't want to leave it to the IRS. How much does spent on probate every year? $2 billion a year are spent on probate. And 50% of the probate costs goes to attorney's fees. Now, I'm not saying you don't pay an attorney and you want to have a good attorney, but there are so much in probate that is spent that could have been avoided with proper planning. And 63% of Americans do not have a will or a trust. So if you don't have one or it's old, don't be embarrassed. You know, this is more of a majority than a minority that does not have a proper estate plan in place. Or they have the documents, but they haven't done the other important factors. Your estate plan is not done just by getting your legal documents. Also, beneficiary planning is extremely important, okay? If you have a beneficiary on the account, that's where it's going. We're going to talk more about that, but it's really, really important to make sure that those beneficiaries are correct as well. So estate planning isn't about how much you have. It's about making sure what you have goes to who you want, when you want, in the way you want, without unnecessary cost, delay, or conflict. So let's talk about estate planning a bit more in depth. And when I think about estate planning, I think about really kind of in 3 areas. Number 1 is the documentation. Okay. So there's a will. There may or may not be a trust. There's durable power of attorneys. Okay. There's advanced healthcare directives. Who's making your healthcare decisions? You could utilize a ladybird deed or a transfer on death deed, depending on what state you're in. You could have prearranged funerals. That's kind of the document side. And unfortunately, we see a lot of times where people do get the documents done, but then they don't go to step 2 and step 3. And then really, it is not the most effective estate plan for their situation. Then there's strategy. Is there stepped up or cost basis involved? Do you have tax bracket management? Do you want to utilize Roth conversions to help pass more on to your beneficiaries? Do you utilize qualified charitable distributions and help offset your required minimum distributions? Do you have a gifting strategy? Are you able to give out, right, money that will not be taxed to them? You don't get to deduct it, but it gets out of your estate. 529 plans. Do you have children or grandchildren that you want to help with college, and have you utilized a 529 plan in the strategy? And then life insurance. If you have life insurance, is it set up properly with beneficiaries, making sure that it's going to where you want to go? Are you utilizing life insurance as a strategy? And then the implementation part, really, really important. On the left-hand side is the documentation, and we think about strategy. Implementation often is missed or overlooked. You get your estate plan done, you've got the documents, a nice binder, everything signed. Now what you have to do is you have to make sure everything's properly implemented. So do you need to make ownership adjustments? Do you need to move, ownership from an individual account or joint account to a trust? Do you need to change beneficiaries, as we talked about? Do you need to fund the trust? Do you need to change titling? Okay. Do you have properties that now need to get titled into the trust if you're having a trust? Okay. And of course, you have to have signing, witnessing, and oftentimes people have multiple accounts. They can have multiple institutions. And so it's really important just to think that through to make sure that from start to finish, your estate plan is in order. So let's talk about probate and what's subject to probate. Number one is your personal property, okay, and your real property. So your home, right? Other personal property is subject to probate. Liquid assets, cash accounts, money markets, CD accounts, brokerage accounts. These are subject to probate, okay? Your business interest, also subject to probate. Retirement and investment accounts. The investment accounts can be subject to probate, okay? Unless they're jointly held and you have proper beneficiary designations. And unfortunately, in a lot of cases, when it comes to assets, especially assets held at the bank, they don't ask you about beneficiary designations, and they don't confirm them. And so a lot of times these accounts have been set up for many times years, and they don't have a beneficiary attached to them. What's not subject to probate is jointly held property. So if I have an account and myself and my wife own that account jointly and I pass away, it passes to her. Okay. What's not subject to probate is beneficiary designated property. Okay. Just remember that if you have a beneficiary on the account, that's where it's going. So oftentimes they'll ask someone, where do you want this account to go? Okay. And they have a beneficiary on it and they say it's in my will. Well, it doesn't really matter what your will says. It will go based on the beneficiary. So if your beneficiaries have changed, the amounts have changed, okay? The percentages, the dollar amounts, all of that, what you want the beneficiary to have, those need to be adjusted. Life insurance, when it has a beneficiary, is not subject to probate. And then property that is in a valid trust. So assets that are transferred to the trust, business interests that are transferred to a trust, and other personal property are not subject to probate. So if you have a will, a lot of people say, I'm okay, right? Well, here's the thing with a will. Okay, what a will does is it enables you to decide your executor and or personal representative, right? Who's going to help settle your estate. And there's work involved with that. So you have to think about that person being able to have the time, Are they located in a, closer to you? Are they out of state? There's a lot of work that comes with being an executor or personal representative. It enables you to decide how to distribute your estate. And then you can name guardians and conservators for minors. So if you're leaving part of your estate to a minor, you can't leave, a minor can't sign a legal contract. So you need to have provisions in there to accommodate that. What a will does not do is it does not avoid probate after death, and it doesn't protect from an incapacity. But a trust is a legal arrangement under which one person or institution controls property given by another person for the benefit of a third party. Real simply, we get asked a lot, should I have a trust? Should I have a trust? And the answer is, it really depends. Oftentimes we see trust as certainly a beneficial way to minimize or avoid probate and do other things within the trust that you want to see happen upon your death. So beneficiary plan, I want to talk a little bit more about this. Do you know that there are two different types of beneficiary designations? Most people don't know this, okay? There is a beneficiary and you leave a beneficiary, but within your agreement with your institution, whoever that is, okay, they have typically a default. But there are two choices. There's per stirpes and there's per capita. So depending on how you want to see your assets passed, you have the same initial beneficiary, okay? But you can see the example here of Jack and Michelle as beneficiaries. Jack is 50% and Michelle's 50%. And Jack has two kids. Michelle does not have any children. You can see that based on per capita, it gets divided differently than it would as per stirpes. So what people want to make sure of, especially if you have grandchildren, potentially are your grandchildren left out of some of your estate, some of your inheritance. And so making sure that you understand the difference between per capita and per stirpes. And then secondly is making sure that's spelled out with the institution. Now, I will tell you that most financial institutions default to per capita, which oftentimes, okay, that's not really what someone wants to see happen. Now, granted, this only comes into play if your primary beneficiary passes away before you do. If your primary beneficiary or multiple beneficiaries are still living when you pass away, those beneficiaries are going to get the assets as you desired in the percentages that you had indicated. But if they had passed away prior to you, which we have seen situations that has happened, and you don't think about changing your beneficiary, well, then this comes into play. And most institutions do this per capita default because it's simpler and avoids confusion. The account agreement or beneficiary designation form will specify, and you need to specify it. So it's really crucial to make sure that you have an understanding of your institutions, how the default is it per capita or per stirpes, and what you want to see happen. So let's talk about some retirement legislation changes that happened in the last few years. What I'm not doing is I'm not talking about the brand new overhauling tax legislation called the Big Beautiful Tax Bill. As we're recording this has just been signed. And so there are obviously a lot of tax law changes. There are a few changes that have happened when it comes to charitable giving and other things that we're not going to dive into today. However, do look for future webinars on the specific changes that have happened with that tax bill. What I'm talking about is the Secure Act 2.0. These were overhaul legislative changes when it comes to retirement accounts. They have a major impact on your beneficiaries and what they will pay on qualified retirement assets, IRAs, 401ks, 403bs, and so forth. So you just need to be aware of that and know that if you have large qualified assets, you should be having a discussion, okay, around how those are going to be distributed. What are the required minimum distributions in the future, now or in the future? How are my beneficiaries going to receive it? Is there anything we can do to help kind of reduce the overall tax nut that's going to be due on those assets? In the US today, there is a large sum, okay, over $40 trillion of assets in retirement accounts that's yet to be taxed. So it's really an important piece for you to consider when it comes to estate planning. What I want to do is I want to take you through a simple situation here on strategy. So we have Norman and Irma. They've been married. They're married, living in a separate property state, and they have 3 taxable accounts: an individual account that Norman owns, a joint account owned by both Norman and Irma, and an individual account owned by Irma. And each account contains an individual stock that they bought for $200,000. So they bought in each account this stock CLP for $200,000. Now the good thing is each account has gone from $200,000 to $500,000 for a total of $1.5 million. And if they sold it, the total long-term capital gain on that account would be $900,000. So the good part is there's a lot of gain. The downside is if they sell it or sell any portion of it, there's going to be long-term capital gains. Well, Norman's not in the best of health and passes away 2 years later. So let's take a look at how does that work from an estate settlement perspective. Norman's individual account is given a full stepped up basis of $500,000. So what he paid at $200,000, he gets a full stepped up basis. The joint account gets half a stepped up basis, $250,000 to be added to Irma's own existing basis. It doesn't get a full stepped up basis because it's jointly owned. Now remember, this is in a community property state, so it's different in different states, but this is the way most states treat it. Irma's individual account, there's no stepped up basis, and that leaves her with the original basis of $200,000. So again, $200,000, it's worth $500,000. So her cumulative basis, right, after it's settled out with Norman, okay, is $500,000 plus the $350,000 plus the $200,000, so $1,500,000. She's left with a potential long-term capital gain of $450,000. That's if she was to sell and need the money. She still has long-term capital gains on her account. Now, the other thing to consider is that there's also a potential surcharge on net investment income of 3.8% plus state taxes. So easily she could create, if she was to sell the account, a $100,000 tax bill. Now, Norman and Irma could have taken the advice and transferred the stock into his account and put a beneficiary on that account. And then Irma would have received a full stepped up basis. So she could have had $1.5 million, sell it that day, and have no tax. So this is part of the planning. And oftentimes we see planning changes as we, kind of move down the financial road. And we just want to bring that up. Really, really important. So let's talk about required distribution and qualified charitable distributions. So a required distribution, if you don't know what it is, when you get to a certain age, okay, it depends on your year of birth. You're either going to have it's either 73 now or 75, or you're already in a required minimum distribution period. So you've reached the age. That age has changed. It used to be 70 and a half. Then with Secure Act in 2020, it moved to 72. Now it's 73 and moved to 75 if you're born after year 1960. But ultimately, you're going to be required on all of your retirement assets. So very often we see a client that when we look at their overall what they have in assets, a large percentage is in qualified assets. These are assets that are saved through a retirement plan, and they've been invested pre-tax. They've grown tax deferred, so they haven't been taxed yet. So we do a calculation, and it's based on an IRS table to determine required minimum distribution. How much do they need to take out on a minimum basis? A qualified charitable distribution, okay, is a way to give to charity, okay, through your IRA, through your qualified assets, okay, and it come right off the top from a tax perspective. Another word to say it is you're not taxed. These qualified charitable distributions is a great way, okay, to help save some tax money, and we often see this is overlooked. Folks haven't had the advice on taking these qualified charitable distributions for their charitable contributions. You can start a qualified charitable distribution at 70 and a half. You don't have to wait till 73 or 75. You can actually start those distributions at 70 and a half. So let's take a little bit more of a dive in here and talk about this. So if you look at a qualified charitable distribution on the right-hand side, it's pretty simple. What you do is you take, instead of taking a distribution, you have a check, a distribution made out from your custodian directly to the charity. Pretty straightforward. Again, advantages, it comes right off the top from a tax perspective. The other advantage is it counts towards your minimum distribution. So an example would be if my minimum distribution is $50,000 and I do a qualified charitable distribution of $10,000, I have to still withdraw 40, not 50. The 10,000 is not taxed. Whereas, let's reverse it. If I have the IRA and I take my distribution at 50, and I'm not aware of this qualified charitable distribution option or that it exists or how to do it, and I take that distribution of 50, so they send me that check. I put that check into the bank, okay? That 50 is taxed. I then take from the bank and write a check for $10,000 to the charity. Well, I may or may not be able to deduct that. Now, I'm going to be able to take some of it a little bit with the new tax law. It's going to give me a little bit of a break, but I may not be able to itemize it all. It all depends on the situation, okay, and my financial situation. So that's not the most beneficial. If you do this year over year over year, you end up paying a lot more in tax, thousands of dollars more, okay, in tax than really what you should. So utilizing a qualified charitable distribution is really a great strategy. So let's talk about briefly, for those of you that are new to Hilltop, how we work and what we do for clients. We really operate as our client's personal CFO. That is, we want to be there as a resource, not only putting together a plan and making sure that that plan is staying updated with new tax laws, new markets changes, other changes that happen, but also as a resource when situations come up. So we work through financial and retirement. We talk about insurance. Do you have the right types and amounts of insurance? Medicare planning. If you're not yet on Medicare, when you get there, there's going to be a lot of choice there. And to have a third party, someone on your side that's not selling Medicare, helping you through those choices. Taxes. So we as a firm, we do tax preparation. And so that is an offering that we have, but that's not really the big part. The big part comes with the tax planning and mitigation, wills, trust, estate planning, and then asset management, based on your goals, your risk, right? And how you should look at it from a perspective of where you're at in your financial life. Who we work with as a firm, we work with three main categories. First one is pre-retired and retirees that are already planning, in retirement or prior to retirement. Doctors, medical professionals, and business owners. Those are the three major groups of folks that we work with. What I'm going to offer up to you is that I wrote a book about our firm and what we do, then get people thinking about their retirement. So if you think about retirement or your financial life as a mountain, when you're saving, investing, right, putting kids through college, paying off a mortgage, grinding away, you're climbing your financial mountain. As you get close to the top and you start to come down, okay, that's retirement. Do you realize that in mountain climbing, more than 80% of the fatalities happen on the way down? Not as many, not near as many as on the way up. So I think about this from a retirement or planning, financial planning, retirement perspective. There are a lot of decisions to make on that downward climb, right? That as you come down the mountain. So you could go ahead and take a screenshot of this, and it'll take you to a link. I want to give you the book for free. You can also go to hireapersonalcfo.com to find out more information, okay? But also get a free copy of the book. I think you'll find it very beneficial. In the book, we cover not only estate planning, but we cover all aspects of retirement planning. Other next steps. If you're a current client and you've been thinking about an estate plan, maybe you've talked about it with your Hilltop advisor prior, talk to them. Let them know that you want to get moving on the estate plan. Again, we constantly are reminding people about this. We see every year the other end of not good planning when it comes to estate. And I will tell you that it usually doesn't end up well. It just makes it more complicated. There's a lot more costs involved. A lot of times beneficiaries end up not being happy. There's arguments between inner families. There's a lot of that can happen. So discuss it with your advisor. If you're new to Hilltop, then the next step is to schedule a 15-minute introductory phone call. On our website, you'll see where you can actually access that. You can get online, schedule that call, and it's real easy. We'll find out a little bit more about you. You find out a little bit more about us, and then we'll determine if there's a fit and to schedule an introductory call or meeting with a wealth advisor. There is no cost. There's no obligation. We want to make sure that it's a right fit and that we can help you. I hope you've had some good value or got a couple pieces out of this estate planning session. It's really important to make sure that this piece is in place. So please take the information, utilize it. And until next time, I hope you have a wonderful, wonderful day.